He's now a mediator and arbitrator with over 400 cases that he's heard in the last 20 months. He also represents lawyers in disciplinary proceedings before the bar and in federal court. As solo and small attorneys, let me say that there's sometimes a worry that the larger firms that have a greater volume of work might get a preference with mediators or arbitrators. You don't have to worry about that with Judge Hilder. He's not here to promote his practice, but I will say that if you have an opportunity to mediate a case before Judge Hilder, take it. With that, thank you, Judge Hilder.
Thank you. Okay, is this working? Yes, it is. You know, I hate this room. I don't know about the rest of you, but you either go too far that way or you stand at the end and frankly, it's an eyesight issue, and I forgot my hearing aids. I got to tell you that, too. You know, I don't think I've ever spoken to the solo, small practice, rural practice group. In fact, I'm pretty sure I have not, although I'm recognizing quite a few people here. One of the things I'm puzzled about a little, you know, as I do speak way too often, and I'll ask you about this topic in a minute. I think you hear it way too often. It's a rule that says you have to hear about professionalism, right? So do I now. But these days, it's gotten to the point, sadly, where I'm almost always the oldest person in the room. I'm looking around here, guys, and I'm not the oldest person in the room, or this solo practice ages you very quickly. And I am one of you. I've been basically in a very small practice with my wife since August 1, 2011, and it ain't easy. I'm very fortunate. I'm a solo practitioner, really, because my wife does a lot of other things. We do nothing together because I do a lot of mediation and arbitration. But what I have found to be incredibly difficult is to try and litigate, which I'm doing in some cases, without the support, without, you know, how many associates can I dump this on? I don't have any such thing. Most of you don't. And if you do, it isn't enough. And now we have e-filing. I'll tell you a story about e-filing in a minute, but I put it off and put it off and put it off. It became mandatory on April 1, and I still put it off, but I finally filed something on April 3rd. And on April 5th, I had a hearing, when was it? Wednesday, in a domestic case. Why the hell I'm doing that? Well, it's family, but why the hell I'm doing it anyway is another very good question. And then the following week, I had to do a filing, and everything went to hell for me. And it happened, I had to file by midnight. I'm still going at it at 2 a.m. I'm too old for 2 a.m., by the way. I had to do it by 2 a.m. I'm still at it. It wouldn't work. And I was getting a little distressed. So what I did, my opposing counsel is a nice enough lawyer of the vast experience of 18 months. She's told me many times that she doesn't have to listen to anything I say, which I said, probably shouldn't have told her to call me Your Honor. But I tell you, on this e-filing thing, I just got to share this with you a little. So everything went wrong. It's a hearing before a commissioner. How many do domestic work? You know, I actually care. I mediate domestic. I think it can do a lot of good. I was on the Family Law Executive Committee. I believe in this. I even did it at Christensen Jensen. But it ain't easy. It takes so much out of you as a person. So I did my best with the e-filing, right? But it didn't work. And I actually confirmed the next day it was the Tiberius system. It wasn't me, but I thought it was me. So I write, Dear so-and-so, and I'm writing this at 2:24 a.m. on the day the filing was due. I am in e-filing hell, and maybe just general computer hell. As you know, I have sort of successfully filed a couple of things, but here it is 2 a.m., and not only can I not get past error messages when I try to file, I cannot get the thumb drive to activate so I can transfer documents to another computer. I thought that might be the problem. It wasn't. My sent emails are erratic. So I said, I cannot get it done, but what I'm sending you here is my motion response and my 4 declarations, and I will deliver the exhibits by noon. I'm asking you to consider those, look at them, and I will somehow get the e-filing done in the morning. I get back at 12:33 p.m. Robert, these are unsigned declarations. The certificate of services are all messed up. The attachments are missing and they are filed untimely. It's too bad you waited until the last minute to do this. And then she objected to my filing. Now, she had to file by the Friday, well, a week ago today, and I get something back on about Friday saying, I will accept your late filing if you will accept me filing by midnight Sunday. I wrote back and said, you can file till 10 minutes before the hearing. That's good enough for me. I don't care what you do. She actually filed then, very early in the morning. This is about professionalism, isn't it? I'm out of order, but I'm enjoying it. So she files herself, this was sort of funny, around 1:38, 2 a.m. on Tuesday morning before the Wednesday hearing. I didn't object to anything. A couple of lines I loved. The first one to the commissioner. Respondent will allow the court to accept the late filing. Allow the court. That is an 18-month lawyer, isn't it? How many have been before Commissioner Patton? Do you think he needs your permission? I found out Wednesday he doesn't even want to hear what I have to say. But she would allow that, she said, which I thought was pretty kind. She didn't say why she would allow it to accept mine when hers was late, but she knew I promised her I wouldn't say anything. I never said anything. But then we did step into a funny area. One of the hardest things in dealing with this particular lawyer, but I've run into it before, you know, positions on professionalism, civility, it's like everything else that's happening now. Our new word is evolving, isn't it? I'm evolving on same-sex marriage. I'm evolving on how I care about climate change. I'm evolving on gun control, and I'm evolving on what courtesy is, I guess. But I am evolving on what happens in the real world. I practiced law. It was different. It really was. When I practiced before, there weren't that many cases that mediated. Now, no one wants to talk to each other until they're mediating, which I think is a wonderful thing as I look at my bank account. But I'll talk more about that maybe a little later. So anyway, we're evolving. But one of the things, and I think the rules of professionalism, the standards of professionalism and civility, do encourage us to not, as lawyers, just be the mouthpieces of our clients as we look at what we need to do and what sort of courtesies we extend. And I think also a true lawyer, one of the great things we can do as lawyers, one of the things we can do as legal thinkers, we all were corrupted by law school. We started to think differently, but some of it was a skill. One of those skills is identifying the truly viable options. How many people do you have as clients or opposing parties who sit there with all the things they want to happen and that we can settle if you'll do this for me? And maybe one or two could possibly happen in the real world. You know, like, I hate it in divorce, it's sad, but I listen to a person often, 35-year marriage, and what I hear is from typically the wife, not always, I was married to him for 35 years, I just want to have back everything I had before he destroyed my life. Well, when he was destroying her life, he was destroying his life. There's nothing to have back. It's all gone, all gone. Sometimes it's there, normally it's all gone. So that's not a viable option. I want the judge to not only give me $10 million, but I do want this person to have his fingernails pulled one by one and electrodes attached in awkward places. Well, there may or may not be 10 million. The electrode issue is a little harder. Okay? So that's not a viable option. So I think as lawyers we have to try and educate on that. So, okay, confession time. And talk about evolving. I became a judge in '95, and I'm thinking about that today because I'm looking at Frank Suter over there, who I believe hasn't aged since at least 1990, something I resent rather badly. But Frank was chair of the nominating commission that sent me up twice to the governor, the second time I got through and was appointed. He treated me extremely well, and I'm grateful to him, and I've hardly ever seen him since. But I do thank you for that, Frank. You gave me the best professional opportunity in my lifetime. But I've evolved a lot in different things I do, believe, am. And among other things, I guess I'm not old, but I'm getting too old to care too much about people knowing I'm a real person. I make mistakes. I get divorced. I get remarried. We all go through things. Some of you don't. Some of you do everything right all the way. I haven't. Like I got 7 kids. I have 2 beautiful dogs. If I'd known about the dogs 35 years ago, I wouldn't have any kids. But we all make those mistakes, right? Well, what I did do in my second marriage was marry a younger woman. Not young, but younger. In my case on Wednesday before Commissioner Patton, I got a 24-year-old man, a 22-year-old woman, 2 beautiful little kids who I've come to know because the case has dragged on since a month after I retired. And by the way, I am in it because of family. My wife took the case. She's wonderful. She's a lawyer, but she's a new lawyer. One reason we have a firm is, where do you get a job unless your husband or father or someone opens a firm? But she wanted to try domestic law, so she took an in-law's case. I said, I'll support you on this, son. She said, good, I just want to try it. She went to Commissioner Patton once, and again, after Wednesday, I sort of get it. She left the room, and she won't forgive me for this, but she doesn't know, because right now she's under anesthetic having a colonoscopy. So don't tell her, okay? She comes out of the thing, goes into the restroom and throws up. She goes back a second time. She comes out of the hearing, goes to the restroom and throws up. She comes back to the office. She drops it on my desk. I'm done with family law. I said, wait a minute, it's your case, it's not my case. She said, don't talk to me like an associate. So it's been my case ever since, okay? And as the woman, I'm on my 3rd lawyer on the other side, but this is great. This is a great world we're in. The 2nd lawyer I suspended from practice after a trial. All I know now is I should have disbarred her. And Judge Toomey prosecuted. Judge Toomey, who's a good friend, met me for a drink just after I got that case, after that attorney came on. I said, you won't believe who's on the other side now. She said, it serves you right. So, anyway, I'm rambling, but there's a theme. So I take over the case. I'm hating the case, and I let the newest lawyer know, she's been on since about January, that this is really a pain, but it's family. And she, of course, responds and says, it's not my fault, it's your family. I'm sorry, but it's not my fault. I said, well, that's nice, but I said, it's not him that's family, it's my wife who's family. I've got to do this case. So I'm doing this case, okay? So early Wednesday morning, this crosses my desk, the declaration of the respondent 22-year-old mom. One of the issues here is this 22-year-old is living with a 46-year-old with a very checkered history, we think, but that's neither here nor there. I've never raised the issue of the age difference, but the young lady's mom and dad have, the in-laws have. It's been an issue. You know how people get and jab at each other for whatever they can think of. So although I haven't said it, I get in the 2nd page of the declaration, Mr. Robert Hilder himself has a big age difference in his own marriage. Now, I've been doing this 30-odd years. Would anyone in this room do that? I mean, don't even dare raise your hand. You don't attack other counsel's personal situation. Now, I've told you there's an age difference. I was offended on that one. All the way through I've been okay, but I was offended. And I wrote back and said, you've crossed the line, kiddo. I didn't call her kiddo. I didn't even call her a little girl or young lady. I have learned a few things over the years. And my wife's a feminist. So I said, you've really crossed the line here. My preference is to never speak to you again, but we have a case and we're going to get it done, but I think you owe me an apology. Now, to her credit, she apologized. But her apology is, I'm sorry, but I figured it was just her testimony and I couldn't change her testimony. I didn't write any part of that. Who do you want to tell on a declaration you submit that I know I handed it in, it goes with my motion, I'm the lawyer who reviews it. This is not the first lawyer I've had who has said to me in a judge situation, I know it's outrageous, but that's what my client says. Ain't the way we do business, guys. And anyone who thinks that shouldn't be in law. So I said to her, you don't take responsibility? She said, I don't take responsibility, but I guess next time I'll review my client's testimony more carefully. I'm grateful for that. But what she also won't do, and she told me again and again, I've tried to settle this case with every lawyer, every time. Everything I get is, she is the decision maker, not me. And that has justified not dealing with actual wage numbers for child custody. It's dealt with not bifurcating. They have no reason not to bifurcate. My young client now has a 4-week-old baby with his fiancée. They desperately want to get married. I think they're really committed. We can't get a stipulation, and this young lady blocked the hearing. This lawyer blocked the hearing because although I filed the motion on time, she moved to strike because, and I told her about it, and she had it, and I told her the hearing date. Back to e-filing, I didn't do a proper notice of hearing, so she tried to block that. So I asked to stipulate on bifurcation, stipulate on that. All I get back every time is, she's a decision maker. We're back to viable options. Isn't it our job as professionals to at least teach our clients options? Isn't our job under the standards of professionalism and civility to say what you will agree to and what you won't, and to tell your client, I will do anything I should do to protect you, and I will not give up a legitimate strategic advantage, but I will not harass whatever, and I really probably shouldn't attack the marriage of opposing counsel. Now I have to clarify. I'll be 64 next month. My wife is 50. I told you about the colonoscopy, so she's no chicken. And the difference is 13 years and 8 months. Now, I don't care if you hate me for that. I don't care if you like me for that. The difference in the case is 24 years. But I mean, the point is, why would you do that? And why would you not take responsibility? And that wasn't even the introduction to my remarks today. You've got me on too long here for an hour and a half. I do engage a great deal now on professionalism and civility. How many of you still, when you walk back into your old law school, have significant problems with gastrointestinal problems, PTSD? Yeah. I taught for 3 years at the U, late in my time on the bench, and I got closer to walking in without nausea, but only closer. Going back to my law school, there are people who like law school. I wasn't one of them. I hated almost everything about it except the friends I made, so many of whom are still friends. And I love what I became, a lawyer, because this is the profession of my dreams. I got to it late. I got my GED at 30. I got my law degree at 35. I'm so grateful that happened. I identify as a lawyer, frankly, more than I do as a former or retired judge, but I love the whole role of the law, the judiciary. I also think we're very imperfect. But it is difficult for me to say that it's been all good. It hasn't been. It's been difficult. Now in this building, I hate to admit it, there could well be someone in here from the Office of Professional Counsel, all of whom are good people. But after now 11 cases at the OPC and 1 in the federal court, I've got problems there, and I'm going to talk to you about those. I have an appeal now up at the Utah Supreme Court on an ethics issue, and this engages me on the issue. And we're going to talk about the judicial proceeding immunity, which, where this all comes together is in the dilemma between professionalism, civility, courtesy, and true and appropriate zealous advocacy. And that's what we've got to do. And I don't know how many of you litigate. I'm suspecting in small practice you do what you have to do to eat the next day, and that often includes litigation, not always. Where I grew up, it was a barrister and solicitor distinction, and I worry a little bit that I wanted to be a lawyer because I thought I'd look really good with the white wig and the black robe. I finally got the robe, I never got the wig, but the distinction was pretty clear. Here it's not. Most of us go to court sometimes. But the principles of zealous advocacy apply in almost everything we do. Every negotiation, every business transaction, every ability to try and help someone resolve a dispute with a neighbor that isn't litigation. So these, I think, apply to all of us. I do need to know quickly, because I think at this point, we're getting to the point where those, if any, who attended the BYU local government seminar 3 years ago today should leave if they don't want to hear some things again. Was anyone there? You were? You can leave now. You will hear some things again, I hope with a different take. But the reason I have to talk about them more than once is I'm evolving seriously. I'm trying to understand these things, and I'm working with the Rules Committee on Professional Conduct. I'm working with another group of lawyers who have some concerns about the role of the OPC Council. And this isn't an attack on the Council. I think they're wonderful people. It's on the idea of what their role is. I always want to ask this question, but I really don't mean it, so don't take me seriously. All of you raise your hand if you've been disciplined. No, don't do that. Okay? But if you've been involved in the process at all, one thing you may know is it's actually pretty easy to understand. If you're a family lawyer, if you're a small practice lawyer, if you're a criminal defense lawyer practicing privately, you're far more likely to have a complaint filed against you, often by opposing, not counsel, party. This is what happens in that world. And it's a difficult situation for you all. And they're the people I've been representing. But it's also a system that is so different. The OPC is described in the rules as the prosecutor and as the secretary or staff to the Ethics and Discipline Committee of the Utah Supreme Court, which is the one that sets up and convenes the panels. Here's the issues at the screening panel, and here's the exceptions if you take an exception. And that exception, of course, results mainly from so-called informal discipline. But in that role, I have found unequivocally that the OPC, they're candid. These are good people, and they've done it a long time, and they're committed to their role. And I have to keep saying this because they may be able to hear me. They're just across the hall. But I mean it. They're good people. But they take the position, apparently, they do an initial screening, which I think is a very fair and balanced thing, and it does weed out a lot of cases. Once they get past that, if they file a notice of informal discipline, and it's called a notice of informal complaint, NOIC. When that's filed, their position is, we're going to give that screening panel, which allots up to 1 hour to hear your case and may consist from 3 to 8 members, including 2 public members and the rest are lawyers. We're going to give them everything that's given to us from the complaining party. We're not going to take out prejudicial. We're not going to take out irrelevant, because that's not our job. We're not going to say, like a prosecutor would, well, we all know how many do criminal law. Larry, have you done a couple of criminal cases?
1 or 2.
1 or 2 billion? Larry, the preeminent criminal lawyer. So, these people, a criminal prosecutor who understands the prosecutor role will overcharge. They'll throw in a couple of felonies, a couple of misdemeanors. I've done many, many, many criminal cases as a trial judge. And if the case settles, it'll always come down to 1 or 2 counts, and typically a reduction. That's okay, that's a system, because what the prosecutor does is bargain, discuss, consider the evidence, and consider whether that evidence is admissible or relevant, and then come to a determination of what's a reasonable resolution. And like anyone bargaining, and you've all bargained, you don't give your best deal right up front. That's okay. The OPC throws in any rule they can think of that might apply, but they say they don't really advocate that that rule applies. And this is from their mouth to my ears. They've been really good. They talked to me, we've sat down. I've acted like a crotchety old man sometimes, saying, how can you do this? We need to talk. And they do talk to me. They've always been good about that. But they will keep throwing in counts. Now, under the rules of lawyer discipline and disability, and by the way, we all should know this stuff. Do you think I read a single one of those rules in my entire life except when I was trying a discipline case? Now I've damn near got them memorized. But you don't typically read them. You need to, but unless you're doing it in the context of a proceeding, it's hard to really see what's going on. But under those rules of lawyer discipline and disability, which deal with the process, you're supposed to not have a hearing with the screening panel sooner than 30 days after you have notice of all the issues. Last one I did, I've done a few. Last one I did, a week and a half, 2 weeks before, they already had about 5 rules in there. Another one got thrown in. It didn't say why it applied. It didn't refer to the facts that make it apply. I filed a very short motion just saying this should be thrown out. We got to the hearing. Nothing had been done, but the chair, and I've got to tell you, the panels are generally excellent, although sometimes they get hung up on something, and that's part of the reason that's not relevant, and it goes back to the NOIC. But the chair said to me, so what's the issue on this extra charge? And I said, well, my issue is really notice, but secondly, we've been given no indication why it even applies. And of course, the position they take also, the OPC and the Ethics and Discipline Committee, is that they can throw out every possible rule that's been thrown up against you and pick their own. And the case I've taken to the Supreme Court is like that. I'll tell you a little more about that in a minute. So, the answer from Bar Council was, or OPC, not Bar Council, there's a true distinction. That's where you go for unauthorized practice of law. Bear that in mind if you don't have a license in here. Okay. So, the answer was, we don't say it applies, Madam Chair. We say it might. We don't give any reason why, but our job is to tell you everything that might work, and if it's a week or if it's a day off, we do that. Well, I think that's improper because there's this little thing called due process, but I'm sure some of you have read the discipline cases. The bottom line is that the Supreme Court has plenary authority over all discipline cases. They set the rules, they change the rules, and they completely determine and set the standard for due process. And their answer is it gets the process it's due, but if it's informal, that's not very much process. And here's the part that really kills me. They say that the public one that's bad. Up to a private admonition, we don't hear about it. We read those little anonymous blurbs in our bar journal, right? Then that's a public reprimand. The panel can do that. And if the panel does a public reprimand, unless you do an exception with the chair, which I've done in the case I have now up on appeal, there's no review. But if the chair does, in fact, sustain what the panel did, then your only review is with the Supreme Court. Now, my position, I feel it strongly, I don't know how many of you feel it differently, is that a public reprimand ain't minor. There are areas where it might be. There are lawyers who perhaps are so under the radar no one notices. Some of you are rural, I think, I'm not sure. But you're all part of a community where we talk, we spread the news, we know what's going on. A public reprimand is a significant impediment, I think, to developing a good reputation. It has the risk of destroying a reputation that's otherwise stellar. My lawyer in the appeal has practiced without blemish for 32 years. Now she's got a public reprimand. And here's the really cool part. We're going up to the Supreme Court to talk about that, and we have to put her name all across the bloody reporters and out in the open record to say she shouldn't have a public reprimand. So my argument will be, and one of my arguments, if I ever finish writing my brief, and I will because it's only a couple of weeks out till my final deadline, but my argument will be, number one, a public reprimand is not minor. If you're going to do a public reprimand, send it to the district court, like you do on everything higher than that. On another case, I got dismissed. I said to them, the bar had said, the council had said, we think it should be a public reprimand or it should be sent to the district court if you consider it more serious. I said, if you think it's more serious than a private admonition, I beg you to send us to the court. Because there we're going to get due process. There we're going to get rules of evidence. There we're going to get the chance to cross-examine witnesses. I said, throw me into that briar pitch as soon as you can. And I'm going to tell the Supreme Court that. They may not listen. But my position is, if I have a choice between a public reprimand, and I'm going to talk about this in the judicial proceedings, immunity and civil suits later, and either a civil suit or being at the bar, I will pay the filing fee of the other side for the civil suit. I want to be where I know how a lawyer functions and I know what the protections are. So that's just a quick take on some of the things that are coming up there. I'm going to move in to a discussion of the judicial proceedings immunity. Now, there is no excuse for not knowing that in detail because it's been around 500 years. Well, on the other hand, we talk about it about every 50 to 100 years. So did anyone read Moss versus Parwater? It came out on the first Friday night of July in 2012. Anyone remember that case? You know, I don't know. It's just, I know I'm sick. But I'm sitting on my sofa up there in Park City on Friday night. I actually am in the middle of this case I told you about, right? Let me back up and give you a couple of facts and see why it hit me so quickly. But I do read the appellate decisions every week. I read them on Tuesday and I read them on Thursday and Friday. By Friday, of course, it was 8 o'clock. I was having a glass of red. and I was reading the decisions, which makes them much more palatable. But I read them because I want to understand what's happening. But this is the core behind, and I think this has to do with professional. I'm trying to make this far less boring than the typical, you need to be polite to each other and we should discipline lawyers who are rude. And so I hope we're doing okay. Stop me anytime with questions or to derail me. But I'm going to give you a bit of background on why this leaped out at me. What my terrible, terrible lawyer did, well, I won't go into too much here, but she really did inadvertently but negligently, and the panel found it was negligent. They said, it was interesting, they said, we cannot get past the finding of negligence. Like they're really trying. But they couldn't get there, so they said, negligently my client accessed a record that was confidential, and it was one of those things, speaking of small practice, she was in an office share. And if this doesn't settle, which I don't think it will, you'll read the decision in a year or two. You'll hear what happened. But not now, I won't tell you too much detail. But she's in an office share. Prior to that, this is a divorce, and it's a divorce where, ironically, the mum, who was Australian, you'd think she'd know better, an Australian mother was taking the kids back to Australia. That was her desire. The father was opposing it. The mom testified during a hearing. It was a multi-day hearing that was broken up a bit. And in one day, what the mother testified was that the husband had never worked with her, never been responsive to a proposal to settle the matter, not offering the settlement to prove liability or fault or whatever, but offering that to say, he didn't try, he waited too long, the kids are now ready to go, you know, that kind of thing. But it was, to my lawyer's belief, a fine litigator, a complete lie. And she went back to the office because the mom's lawyer had previously been a partner or employee with the group she office shared with. And very foolishly, this was fixed, but it was there. They had a shared computer system. They could get through stuff. They shouldn't have been able to. The thought my client had was, I don't want to see any documents, but I'll bet you that the last change date of the document that was sent is going to show that this woman lied by a factor of that 1 year. I know it was sent to him like a day before, it was a time issue. So she didn't look, but she instructed her secretary to check out the time log. None of us think that was right, including my client. Only the log, print out the log and get the date. That's what happened. It's been treated as the greatest invasion of attorney-client privilege since I don't know what. I'm not suggesting for a moment it should have happened. I am suggesting there's issues about whether, in fact, a public reprimand is appropriate, and more to the point, in this case, so it goes to a panel with 5 allegations. Those 5 allegations are 4 substantive allegations of significant rule violations, every one of them. Although one of them is pretty good. One of them is a sort of a fraud and forgery thing, misrepresenting herself, but swearing to facts that she had no knowledge of. Think about this. You ever had a client where you had to file a declaration or an affidavit, a declaration? It had to be done that day, and your client's in, these days, Afghanistan. This client was out of the country. It wasn't a client, it was a third party. So with the third party's approval, my lawyer wrote, signed with the authority of so-and-so by so-and-so lawyer, original will be filed in 3 days. They went after her on that one for fraud and forgery. Now, the panel, there were 4, and then there was 8.4 AOC. You ever heard of the one where if you violate a rule of professional conduct, you violated another rule? It's a great rule. It's actually the last 2 times the Supreme Court has looked at it in the last year. They've called it the piling on rule. They've directed the committee to go back and change it. Someone here is working very hard on it. It's more complex than you'd think. That's the trouble with these rules. They're so complex and interconnected. It is not as easy to say it has no place. And I really know a wonderful lawyer who isn't too far from my eyesight here, is trying to make it work. But the point is that rule only applies if you violate another rule. Well, in this case, there were 4 substantive rules, I'll call them. The panel said none of these apply. They threw all 4 out, came up with 2 of their own. So you have no notice on those 2, right? And one of those rules I think absolutely doesn't apply, and the other one is conduct prejudicial to the administration of justice. Well, shortly thereafter, Justice Nearing, in another case, came out and made a pretty good statement about what's it mean to be conduct prejudicial to the administration of justice. What they alleged my client did, this is the panel's decision, is she required the court to hold a hearing on the issue of whether she did something wrong in discovery. Rather flippantly, but I didn't mean it to be flippant, and in my response, I didn't do the panel, I did the exception in that one. I wrote a memorandum, spoke to the exceptions chair, and said, you know, judges hold hearings. That's what they do. This is a divorce. How many divorces that are litigated, I said, not a hearing over some dispute in discovery or something of the kind. That's not what that's about. The Supreme Court said very clearly, but it was later. We're looking at, the standard used to be moral turpitude, but even that doesn't necessarily deal with it. It does deal with the issue of whether the conduct is such that it's antithetical to the practice of law, to the character and conduct of a person who practices law. Now, I'm not going to pretend that if there's a finding that my client truly invaded the attorney-client privilege, you could probably say that. But that one will turn on a couple of other issues. But that's what we had. Conduct prejudicial to the administration of justice, and the other one was, it's Rule 4.4, it deals with how you deal with a third party. And the argument I make, but it's not clear yet. It's not clear in the law, I don't think. When I'm in a lawsuit with somebody, the other party is the other party. Someone else is a third party. The only person involved here is the other party. There are rules that talk about how you deal with a represented client party. There's rules about how you deal with a non-represented party. They're all of the four series. They're all separate. I'll leave that alone for a moment, though, and go to the point that troubles me the most. As I said, the panel said, no question, negligence. We couldn't get by negligence. We did all we could to find evil intent, but we just couldn't get there, okay? So, Moss versus Carl Wallops. Oh, don't you just love who it's against? And it's not just Carl Wallops, it's against Clark Wallops, Judge Wallops, and a very fine lawyer himself, and Jonathan Haythen. I'm not telling any secrets, it's a published opinion. I'm sitting there on my sofa reading this. My client, as I say, looked at a printed log, no substance. Carl Wallops were in an intellectual property dispute with a former employee. Non-competition, theft of trade secrets, that kind of thing. They managed to get a judge to give them an order to say, you can go to the employee's house, you can go in, you can search the house, you can confiscate computers and all that kind of thing. No search warrant. It wasn't a criminal case. And interestingly, this issue was never finally decided because overall the case was settled. But they get to the house early one morning. The man they're going after isn't there, but his girlfriend's there. So you ain't coming in. So the deputy sheriff, and I got a lot of good law enforcement friends, he said, I can kick it in. And he would have. The lawyer had the good sense to say, well, don't kick yet. I'll go get a better order. So the deputy stood there, the lawyer rushed off and got a different order, which was really a writ of assistance. You've seen that, I suppose. Directing law enforcement to assist in the execution of civil process. And so that's what happened. They went in, they took, they confiscated. So the case settled as far as the employment and intellectual property issues, but the affronted householder and his girlfriend sued for all sorts of malicious abuse of civil process, other torts, etc. And in Moss versus Powerwater, issued a July 6, 2012, and I literally read it the night it came out. The court went back and considered the privilege. Now, the privilege emerged. It is 500 years old. It was basically defamation-based. And what it was trying to do is say, you know, if you're going to do something within the context of a judicial proceeding, you've got to have protection because we have policies that really matter. We had a decision in the 50s that basically says we support that. And we got this one in 2012 that says we're addressing the trend nationwide to expand it not just to things you say, but to conduct, which fits, of course, what happened in the Moss case. It fits what happens in my case. The question is, So what we're going to do is reaffirm that the judicial proceeding immunity applies to acts and not just words, and it is absolute where it applies. Now, absolute where it applies. It doesn't apply to everything. It does not apply if the conduct of the lawyer is fraudulent, criminal, egregiously abusive or frivolous. It does not apply in some cases of malicious prosecution, but that's a tougher call to make. They make that a very high bar to sue a lawyer for that. And they say that we can generally protect against problems that occur otherwise by the power of the courts to regulate cases before it, which to me, that's exactly what should have happened in our case. In fact, the judge did it. The judge had a hearing. He disqualified counsel, but he was so not perturbed that he said, I'm disqualifying counsel, but there's no problem, let's finish the hearing. Then you're disqualified. That's not a case of where someone went so far that they had created a prejudice or a problem. So that's what the judge found. But if you do those egregiously frivolous things, there's no privilege. If you don't do that, the privilege is absolute. But the privilege applies to civil suits. There is case law that says quite clearly, but if you can't do by an end run or a different approach what you are barred from doing under the judicial proceedings privilege. And the reason is the privilege is intended, now we're getting to be lawyers, to promote the integrity of the adjudicatory proceeding and its truth-finding processes. It exists for the purpose of preserving both the integrity of the judicial proceeding and the associated quest for the ascertainment of truth that lies at its heart. And there's a part where I'm still evolving, but I feel very strongly, and I'll illustrate how strongly in a minute, that if we start to eviscerate the process that gets us the ascertainment of truth, maybe we want to do that, but it means we're going to go to a different system. Because this is the system we have. It's called adversarial, and it works. And if we make it so lawyers are so timid that they can't do what they need to do, we have destroyed the role of the lawyer. And they get into that. I won't tell you. It's in here. You should read it. You really should. It's a good read. One of the points the Supreme Court makes is, and it's Justice Durham, the Supreme Court makes is that we can't have a lawyer who's trying to represent a client looking over his or her shoulder to protect the self, okay, at the expense of the client. And that's exactly what we do. Well, my simple argument, simple and it probably will be rejected, is, okay, if that makes sense, members of the court, why on earth would we expose them to the processes of professional discipline, including the possibility of public shaming, suspension, or disbarment for doing what you said they have to do without looking over their shoulder, unless they engage in this egregious conduct? So I think that is really where we're headed. There are exceptions to it, but the exceptions protected, and I think as a general rule, matters that happen in the course of litigation, which is generally the judicial proceeding, but judicial proceeding is very broad. It can be all sorts of things you do. It's about representing the client. So if that, in fact, is what happens, then we cannot invite them to divide their interest between advocating for their client and protecting themselves from a retributive suit. That brings me right back to how the heck are you better off at the OPC, where it is often retributive by an opposing party, particularly in family law, and you get an hour. You don't get to directly examine or cross-examine anybody. Most questions have to be asked by the chair. One of the things that frustrates me, and frankly, is that I guess not many people get a lawyer when they're before the panel. Get a lawyer. If it happens to you, get a lawyer. But when you do, you'll go in and you'll sit beside your client as a lawyer, and the chair, doing what they do, will look at your client and say, now, Miss So-and-so, this is how we're going to proceed, and then at the end, you'll have the opportunity to speak to us, unless you'd like your lawyer to say something. It's the old potted plant thing. I'm not going in there as a potted plant. We have a lawyer role. But you've got an hour, it's not enough. Okay. So that, well, my favorite part about this decision really is, 9 months ago, the Supreme Court said that you cannot sue these good lawyers, Judge Wallace, Mr. Hafen, Mr. Matkin. I agree, you shouldn't be able to. They didn't say you couldn't lodge a professional discipline case, and a couple of times I've asked, when are you going to file your claim against these guys? Bring Judge Wallace in. Let him explain what the hell he was up to. Obviously that's tongue-in-cheek, but I don't think it should happen. But where's the logic of not saying it? If it applies in one, it applies in the other. And what I want to see there are changes in rules. I want to see something, but I think it's got to come from the Supreme Court. The Rules Committee is very dedicated and very careful. I've sat through a couple of meetings now. It's not an easy service to sit through the way they go through a document or a rule or a word. It's not easy at all. But they're looking at it. But they really need direction from the Supreme Court that will adopt this on policy grounds. We'll go through there. So where does it leave us with what? Who are we? What comes first? Zealous advocacy or courtesy and professionalism? Well, let me just say for a minute here, I did have a handout. It's not huge, but you've got it open. Good for you. Go back one page. No, you're right where I was. No, go back one page there. First page of the 4. I'm going to carry about time, but that's exactly Rule 4.4. I just want you to look at that one line down there that I think frames the issue. In the comments, first part, only a few lines. Responsibility to a client requires a lawyer to subordinate the interests of others to those of the client. So far, so good. But that responsibility does not imply that a lawyer may disregard the rights of third persons. It's still so far, so good. But the balancing is what we struggle with day in and day out. Then you turn the page and we go to the role of the advocate. One of my favorite stories. In 1820, King George IV, that delightful offspring of King George III. Now, I may have been born Australian, and a lot of you were born here, but we all have reasons to be pissed at George III. Although mine's a little more nuanced. You had some problems back, I believe, in the late 18th century. You dealt with him. But because of that, he went ahead and developed my home state, colony New South Wales, as a penal colony. Now, that's a tad upsetting to me, but the trouble is, 4 of my ancestors were convicts. Where would I be without that? Literally, both sides, I got convicts. Maybe it's why as much as I love the law, I have moments of irreverence. But so, by 1820, all of my ancestors, convict ancestors, were there. Some we lost. Others, frankly, created families, and one is like my great-great-great-grandfather. I mean, it's so clear they're there. But anyway, the 4th, George III's son, I don't understand him to be a stellar chap, but he married Queen Caroline. Well, he made her Queen Caroline by marrying her, right? Things weren't going well. Probably, you know, one of your family lawyers might have been able to do some good, but I don't think mediation would have helped. So at some point they started living separately, and she was in France, but that's while he was still Prince of Wales, heir to the throne. Then Dad dies, and he's the king. And they thought, well, we need her to come back. They suggested, it was really a bit of a ruse, some dishonest work here. Probably the lawyers told the stories, but the request was, Caroline, come on back. We need you to at least pretend to be his wife, because he's the king now. What he really wanted to do was introduce an act. Oh, they got a special name for the act, and right now I'm not remembering it. But it was an act to address her adultery, and if they found her to have committed adultery, to dissolve the marriage, and she loses her position as queen. It was a big issue in the country. Most of the country liked Queen Caroline better than they liked King George IV. But the members of the House of Lords, where the trial was held, they felt pretty darn strongly initially that they had the right position, and of course they wanted to keep the king happy because he's the one who bestows favours, including peerages. So he was their guy. But a guy named Henry Broome, it looked like Brougham, I like Brougham, but it's Broome. Later he became first Baron Broome, and he became the Lord Chancellor of England, the very Chief Justice guy. That was about 10 years later. But he was a very respected advocate. So he came in to represent Queen Caroline, and he did so with more than a little vigor. He stirred up the people. There were riots in the streets. It was great stuff. And of course he got criticized. How dare you, Henry, create this turmoil for the country? And we will read together. You've already probably looked at it because everyone reads what I send out. I once before, he says to the House of Lords, took leave to remind your lordships, which was unnecessary, but there are many to whom it may be needful to remind, that an advocate, by the sacred duty which he owes to his client, knows, in the discharge of that office, but one person in the world, that client and none other. To save that client by all expedient means, to protect that client at all hazards and cost to all others, and among others to himself. Ooh, that's that immunity privilege going again. Is the highest and most unquestioned of his duties, and he must not regard the alarm, the suffering, the torment, the destruction which he may bring upon any other. 4.4 would say there may be a line there. Nay, separating the duties of a patriot from those of an advocate and casting them, if need be, to the wind, he must go on reckless for the consequences, if his part it should unhappily be to involve his country in confusion for his client's protection. Now, I think that's a little more than we're willing to do today, maybe quite a bit more. But it's a fundamental concept really that different about a lawyer's role. I mean, we have an incredible trust here. We're the only people who get to do this. We're the only people who can make it our profession to speak for and protect others. So for me, we start with, we have to preserve the germ of what Lord Brougham is saying there without disregarding, harming, attacking the rights of others. But when we have to choose, we have to make some very careful, balanced decisions. And of course, I think the judicial proceeding immunity helps us do that when it talks about, you know, as long as you're not abusive, you're not dishonest, you're not criminal, you're not doing something to harass, etc. Many of our rules that deal with lawyer behavior, such as standard attorney's fee provision, 78B5, 825, for example, where you have to have bad faith and meritless or frivolous, they all come down to it, don't go too far. But as long as it's for real, you need to stand up for it. But when I look at that, I think it looks pretty extreme to the lawyer mind of 2013, and it probably looks really extreme to the general member of our society unless they happen to be our client. Then surprisingly, it doesn't look extreme at all. But that's not the whole story. And that's why I included an article that I've used a couple of times, Ad fontes ad astra ad clementia. Now, it's highly likely I pronounced that very badly, but my answer is always simple. You may think so, but that's how we said it in Australia. Okay, so that's how we say Latin in Australia. But the meaning, which I always, ad fontes towards the source, ad astra toward the stars, ad clementia toward mercy. This was written by a youngish lawyer who, after I saw this, I called him. We chatted for quite a while. I was very impressed by this article on this person. This is now 7 years ago, coming up on 7 years ago. It was in an Intercourt publication. He was wrestling with how we discharge our duty to our client, but also try and bring something better into the practice of law. There really are people who think that one of the greatest tools of advocacy is anger. I read a piece not long ago that said, you know, law school begets the adversarial system. The adversarial system begets anger in the practice of law, often used as a deliberate tool. As a mediator, I see that plenty. As a mediator, I don't take it. I either don't deal with it. Now, I always fall back on, you heard I was a bouncer. It's a true story. I was a bouncer. That's one of my best mediation skills. People say, this is my last offer. I'm done and I'm leaving if they don't take it. And I say, no, you're not. They say, what do you mean, no, you're not? I said, well, first, no offense, I'm going to look at you right now and say, I know that's your last offer. You just told me it's your last offer. I know it is. And I believe every word you told me. And I'm going to believe it until you tell me your next offer. But you ain't leaving this room until we at least discuss the response, okay? Now, of course, I'm not going to stop them leaving the room, but they don't. And then, like a fool, I'll sometimes say, you know, I don't have many skills, but I have been a bouncer. You're not leaving the room. But I made a joke about that once in the courtroom. I forget what the issue was. Like many judges, I make really bad jokes. I continue to. And occasionally I'll get a chuckle, not nearly as much as I did 2 years ago, as you all can understand. But one lawyer who wasn't lacking in courage, he stood up, he was polite, said, with all due respect, Your Honour, I don't doubt you're a bouncer, but you're much older now. Which is a good point. And just on Tuesday, I was mediating a dispute between about 15 farmers. It was an estate dispute and it was a neighbour dispute over generations of property. I'm in there with a 70-plus man and 6 of his sons, and they're all huge. And they were on, we did a handshake deal, and if you don't tell them this is the way it is, we're out of here. And I started to say my bouncer thing, and I looked around me, I said, not today. And I joked with them. We actually bonded. After 11 hours, we settled the case, and we were all friends. But, so now's the time. What's a jackaroo? Does anyone know? You seen The Man from Snowy River, the movie? Yes. A great movie. Currently is now 30-plus years old. That's in the foothills of New South Wales. I was a jackaroo there. A jackaroo comes from the Old English again, when primogenitor, all the money goes to number 1 son, but you've got to do something with 2, 3, and 4, particularly if they're wastrels and you don't want them hanging around boozing and everything. So you send them to Australia, to the colonies, gave them enough money to get there. If you're there long enough in those days, you got your land, but you would sort of indenture them in a sense to an established, they called them graziers, and train them to be farmers, stockmen, whatever. That has persisted as an apprenticeship. You train to be sort of a trainee cowboy, stockman, whatever. And I did it in the mid-60s. It's a great job. You get $15 a week and all the mutton you can eat. You only have to work 6 days a week, and you work Sunday unless you go to church with the family. And you have to live with the farm family, the manager or the owner, and you have to eat at their table. That's the benefits you get. I literally did that. So I did sort of relate to my farmer friends down in Juab. But, so people get angry, they want to leave, you don't let them. That's one of the issues you try to work with. But coming back to how we then try to deal with the duties, zealous representation versus somehow we get along in this profession. We suppress the anger that unfortunately comes up as a tool very often. And this chap, he talks about, I just reverted 40, I've been here 37 years, I haven't said chap for 35. Anyway, this chap, or we might in those days say, this cove, he talks about, what is mercy really? Can it make a difference in the lawyer's life? And can it take legal advocacy to greater heights of civility and professionalism? And then he talks about the core of what mercy is, because I think that's what's important. And I think it comes right back to my little experience in the last couple of weeks. He says it's difficult to explain, much less encourage. And then he does a brilliant thing. He cites a concise Oxford English dictionary. Now, in my court, if you cited Webster, you're in trouble. If you cited the Oxford, you're probably going to win. Not entirely true, but I have a great preference. And you think I married my wife because she's young and beautiful. I married her because she has the 20-volume Oxford English Dictionary. Oh, man, I mean, talk about a dowry. I hope we never divorce, because I'll fight like a dog over that. That and the dogs. Okay. So, he said the Oxford defines mercy as compassion or forgiveness shown to an enemy or offender in one's power. Now that's strong language, an enemy, but I like the use of the word enemy because his point goes on. The concept requires the employ of leniency and forbearance at the very moment when a free shot at the other side presents itself. Like at 2:40 in the morning with damned e-filing. Now I'm bitter about e-filing. I think it's a good thing. But I was the presiding judge when it started. It rolled out so badly. It made the judges crazy, it made the clerks crazy, and we had a big battle with the AOC. So I have a bit of a bad taste. But as I'm doing it, I'm sure it's wonderful. Some of you may even love it, but I'm still learning whether to love it or not. But I was in that person's mercy. I really couldn't get it right, and the rule said I had to. I was on about the 8th day of when we had to. So it's not very meaningful. You don't show mercy if you can get it anyway. Now, truthfully, I knew I could get that in any way. I knew Commissioner Patton wasn't going to read a doggone word until a day before the hearing. I've sat in that position as a commissioner as well. I mean, I've filled in for commissioners often. There's too much work. He didn't read it a week early. He didn't care. I know he didn't care. But I also knew that he didn't like, I know he's a technophobe. You always check, you know this. Find out who your judge is. Talk to everyone you know who has dealt with that judge. Commissioner Patton knows he's got to be a technical guy. But I heard he hates it. So I called his clerk and said, does he like courtesy copies? She said, he loves courtesy copies. That's just the way he said it. So she got a beautiful binder from me of everything up to the date of the reply. And at the end of a hearing that was a mixed blessing, he thanked me for the courtesy copies. So do those things. So I knew that. I knew I really wasn't in her power, but I filed the appropriate motion. And then, of course, she gave him permission to read it, so that's what changed everything. I'll allow you to read it, Commissioner. But it's not mercy when they're going to get the extension anyway, where they're going to get the time, where they're going to get to file the document, whether they're going to get a new trial. That's not mercy. That's just giving in to the inevitable. But, so, what Mr. Cavendish defines it as is doing the more than fair. Now, does it kill you to think that you might sometimes do something for the other side that's more than fair? I think it's a little hard to swallow when you're a real lawyer who wants to win everything. And you've got to be careful when you do it. But what goes around comes around, counsellors. Probably, as long as you're not giving up the whole thing, you've got to make that call, and almost certainly somewhere it's going to help your client. So, aiming at mercy, aims above the familiar's lawyer standard, thou shalt not lie, cheat, steal, the rules in the code. I think our rules have to go a bit further than that, but obviously we're not talking about that now. Where is mercy in the litigator's workday? When we litigate, we live with rules and codified consequences to rules that gnaw at us just enough to shroud away our nicest selves, a real us from professional view. If we do that, we give away the chance of gaining that gossamer feeling of unexpected, sweet-nosed relief mercy ushers in. How often? You've had the experience, I know you have, where you've suddenly turned over a file on your desk, you found the thing that you forgot about the deadline, your stomach heaves, or you wake up at 3 a.m. Not one of us has not woken up in the middle of the night and said, what haven't I done? Oh my gosh. Have any of you actually rushed into the office at 3 a.m.? You don't have to answer it, but I think some of us have. And you find, I did miss it. I'm in deep trouble. The blood drains away. Your heart goes fast. You lose a year of your life, and then you call the other side and say, I screwed up. And he says, well, yeah, you did, but frankly, so do I, and we really have set this up. We've got plenty of time. Go ahead and file. They won't object. That's mercy. Why would we do otherwise? I mean, yes, this is the problem. This is where the big problem comes up. And I had it. I just argued my first appeal since I'd been off the bench a few weeks ago. And I was the appellee. And so the appellant filed his brief, did everything right, except didn't understand that we live in a world where a sign on the post office that says open 24 hours doesn't tell you which 24. In other words, it's not open 24 hours. They worked hard, they had it ready, they needed a postmark, they went to the airport, wasn't open in the evening. They ran to FedEx, they did everything they could, couldn't get it in. They sweat, they strained, they couldn't get it in. They missed the deadline. They got it to me in the court first thing next morning with a big motion asking to be excused. And then they said to me, we understand that you would never stipulate to this. We suppose you will oppose it. But I guess that means that if that happens and if they don't let us take our brief, I guess you don't have to respond. You win. My response, I thought about it quite a bit. I called my client and said, you know, we've been fighting. This has been fought for years. I took it over in 2011. You think you have the right arguments. I happen to think the Court of Appeals is going to say, stuff happens. We'll let you file it. But I said, I do not want to oppose it. Whether we'll stipulate, I don't know. If the court wants briefing, we'll talk again. I never got to whether I would stipulate. I just said, I will not oppose, submit it, let's see what happens. the court immediately before he even got to submit it. Said, no problem. So it didn't make a difference. But man, I like working with those lawyers because they like me. We all like to be liked. And we all treat each other respectfully. And you don't forget those kinds of things that are done for you. You don't forget those things that are done to you. And we've all had both kinds. So, what is the cost of mercy, says Mr. Cavendish? A lawyer's first duty is to the client, not the feelings of other lawyers, so the sobriquet might go. Are the critics right? Is mercy antithetical to zealous advocacy? Properly understood, no. Mercy as part of the civil lawyering does not change outcomes. It is not the currency of a zero-sum exchange where grace shown to an opponent must take points from the client. An act of mercy is not an act of professional or proxied sacrifice or martyrdom. I think that's a point we really do have to remember. One of the things that makes me absolutely crazy is when I hear someone public stand up and forgive some heinous act that they don't have any stake in. Like, we can forgive these young men who blew up these good people at Boston. Well, we're not the victims. As lawyers, it's not our cause of action. It's not our harm. It's not our whatever. We don't get to forgive that. We don't get to have that warm feeling of being generous when we don't own the claim. So we've got to think about that. But I do still like that warm feeling when you do something good. It just, makes the days better. This ain't an easy job. I've done it in I've done it in a bigger firm, I've done it on the bench, I've now done it in a different context of both ADR and litigation in a very small firm. And most days are hard. And in the middle of the night's even harder. So, mercy, we'll finish this point with this. I've finished the whole thing if you want to read it soon, but we'll see. Mercy properly understood is never expected or bargained for. There exists no entitlement to it. And once given, it does not immunize. And I think this is important to bear in mind as you think about the balance of whether you can or cannot. It does not immunize the aided from rules in future context. Quite to the contrary, it usually leaves them with a new appreciation for rules, standards, and customs, along with a yearning to return the kindness. Think of how the burdens of a truly merciful act, which may cost one or one's client nothing, might relieve an opponent. Embarrassment, indignity, paranoia about malpractice claims, frustration, anguish, insomnia, and loss of esteem. The effects of mercy are quite real and quite good. And truthfully, it often does cost nothing. I can agree that it might cost something, although it's highly unlikely, for a party in a divorce to stipulate that they could earn federal minimum wage. It happens every day in the courts. But there may be a case where you won't be charged with that. I do not agree that it costs a party anything in the bifurcation I have, just to use a concrete example. Separation 22 months. The first thing I used to support my bifurcation motion was the motion the wife attorney made. This whole motion was about going from a total 50-50 joint custody that's been in place for 22 months to sole custody to Mum, who our argument, and I think the record supports, hadn't even taken a half time. But the claim was she can be in sole custody because she's in a committed, permanent relationship with this 46, 48-year-old man, and her husband is in a committed relationship and has a new baby. Therefore, they are in their own households, their own families, and she can set up a wonderful sole custody situation. There is no financial issue between them. She does not have, she's been off his insurance for a year and a half. And no, we can't agree to the bifurcation because maybe it'll give him an edge in a custody fight. At which I said, you know what? This is 2013. I will stipulate that I will not use the fact of marriage. I will use the fact of a committed relationship, not the fact of marriage. That's all you need. You're not getting another thing. And I said, if you don't, this was after they said no twice, I said, okay, I appreciate it. First, I'm using your statements about the relationship, and second, I'm saying, you want sole custody because your client's in a wonderful committed relationship, but not one so committed that she dares risk being single. She might have to marry the damn man. Okay, but my real point here is, guys, what did they have to give up? They're going to lose it. But what they lost was goodwill. This guy's sort of poetic, and I'm not poetic, but I'd like to be, which is probably why I like this. So we come to the end of this story. I hope you'll read this whole thing. It's just, one of those rare feel-good moments as lawyers. What is the source of that sudden happiness that spreads across us while walking on a day where we don't know hot or cold? Is it the cerulean dome overhead, the extra fresh in the blowing air? Or is it that we never saw them coming? The winds and the weather are fickle. We cannot rely on them for our needed resupply of momentary weightlessness. Instead, we should look for acts that can overtake any expected standard of lawyer behavior, self-initiated events that promise a return loftier than compliance or meeting expectations. And that's where he talks about where we're going. Toward the source, toward the stars, toward mercy. I think that's an excellent aspiration. I think I'm learning it's harder to do in practice. I always reach out with it. In this one case, it got me nothing but grief. And I have been angry. And I've had to apologize for being angry because it's just been a very strange relationship. But that's what we have. Now, I've been going an hour and a quarter. They want an hour and a half. I don't know how you can stand that, but I know you can't leave. You're going to have lunch. I've been a lawyer a long time, like many of you. I've been a judge longer than any of you, I think. I wonder if you have any questions about any topic at all that you would like me to address, or would you prefer I find something to drone on about? Yeah.
I have a couple of questions. One has to do with the rules of civility that started, I don't know, was it 10, 15 years ago, when it was first became a topic of conversation.
Absolutely.
And my first reaction was the judges are telling us to be civil, because there's plenty of judges out there that just aren't. There are some who are not civil to anybody.
Boy, do I like this question.
There are some who, always will be disrespectful and demeaning to a defendant, whether it's a civil or criminal case. And there are some who are just that way to everybody, no matter who it is. And not all judges are like that, of course, but there are enough that it made me wonder, well, why, if you were civil, maybe fewer of us would feel like we could emulate you. And the second point is that, if I'm in an adversarial proceeding and the other attorney starts tearing into me, if the judge would stop it when the other attorney's doing it, I wouldn't have a decision to make about how I'm going to respond to it.
The first part's easier than the second part by a long way, in my view. Just a show of hands, don't name anybody. How many feel you've been treated uncivilly by judges? Mine's up. I believe it happened this week. I don't think it was intended. I think it's one of those cases where don't assume malice when there may be another thing going on. But yeah, it does happen. It happens way too often. And one of the absolute killers is I hear uncivil judges who I know are uncivil. Now, I was a presiding judge for 4 years, which meant I got every full performance evaluation of every judge in my district. There's 28 of us, and the 5 commissioners. And I didn't have a week without some kind of letter complaining about a judge. So I saw the comments, I saw the scores, I saw the letters, I sat down with the judges. It is prevalent, to say the least. Oftentimes it's really not much more. It truly is a perception that's not based upon malice, but that doesn't matter what it does to the people in the courtroom. In Australia, there's a big move. I read the Australian paper every day. It's about the only contact I really have, except the odd visit. It's about the bullying from the bench. They call it that. And a lot of it is bullying. A lot of it's about being the smartest one in the room. I know that's sad, but it's true. But when I was off the bench less than a year, I spoke to a family law group, and rather idealistically, I said, I've been both sides, and you can't let these judges bully you. You cannot take their crap because it's not appropriate. This is not their role. And people didn't really seem to connect with that. Then I started going to more hearings. And Wednesday's a great example. The outcome was fine. The judge's behavior was interesting. He wasn't bad, but he was interested in giving a huge lecture. He was interested in attacking on one particular issue. One of them, I sort of enjoyed. With another judge, I would have had good banter, but that wasn't happening. And I'm not fearless, but I'm not too worried as long as I tell the truth. One of the complaints against my guy was that he didn't call his still wife, but soon to be ex, in the middle of the night when she was in San Diego to say the little boy had taken a few cold tabs that he was having some nausea. It wasn't critical. It had been determined it wasn't toxic, and I foolishly wrote in my papers that he didn't want to call her in the middle of the night, 800 miles away, where she couldn't do anything, and then they had contact the next day. And the commissioner, very early into my responding to an order to show cause on that, said, "Stop there. Stop there. I will not accept that position. It's an outrageous position, and here's why. Some of us, and I can't rule we should, but some of us believe there's a God." Well, so I can't rule there's a God, but I can say that you call immediately because that other party just might want to create a circle of prayer. I'm fine with the prayer, that's not a problem. But he went on about that for about 3 or 4 minutes, about you cannot even stop me that because while I cannot rule there's a God, and it was a loud harangue type thing, not the worst thing I've seen by any means, and I was okay with it. But what I found in that hearing generally, and I've had it a couple of times, I've done this long enough that generally I have a sense where the ruling's going. And if I think it's going my way, even though it's sort of weird and haranguing, I can't stop it. I can't jump up and say, "Now, Your Honour, this is inappropriate." I'm not afraid to do that. What are they going to do to me? I mean, I'll tell you what, they're not going to get me in jail, and you know why? In Salt Lake County. Be careful if you're not in Salt Lake County. There's no bloody room. And when I was presiding judge, I still have Sheriff Winder's cell phone, and I used to have the jail chief's cell phone, but he just became the director of corrections. And we worked so hard together on so many issues. I had a deal that if I called and begged, they'd put someone in jail on a civil contempt as a favor to me, but only for a few days. Well, of course, I was in Provo, and apparently they will put him in jail. You guys may know. But I mean, I'm not worried about that. But I sat there yesterday and said, a couple of days ago, and said to myself, I really want to call him on this because I think it's inappropriate. I think I could do it politely, but I can't risk it changing the ruling. How many have had that feeling? Yeah. So I guess we're back to where your duty lies, aren't we? So how do we fix it? This is actually a very big worry to me. How do we fix it? You're mostly good judge, but I got the letters. Under Rule 3-104, the presiding judge has a hierarchy of things he or she must do to address problems in the bench. Except for that informal thing, which culminates in report them to the chair of the Judicial Council or to the Judicial Conduct Commission, everything else is really just persuasion. Now, you can change calendars. I've changed calendars. I've reassigned people. I've done all those things to try and make changes, but they don't work. Not one of them ever worked. So what you've got here is if people get through one election, and the first election comes between 3 and 5 years after appointment, then they need 6 more years to vest in their retirement, and some will make it, some won't. It's a really close call depending on when they were appointed. But there have been problematic judges I've lived with who probably are going nowhere for at least 10 years and probably are never going anywhere. And what we need is a different system. I've been exploring, but no one's ever going to listen to me, something like a real ombudsman system. It would take someone like a retired judge who can be present, who can talk to the judges, who can coach and try and make it clear without risk of public exposure that you need to make these changes, but the ombudsman's job would then be to report it to the Conduct Commission where it might have more credibility. I think we need movements like that. But without that, they don't change. I've heard senior judges in this state, I've heard appellate judges stand up and say how outrageous it is that the lawyers aren't civil. And one I sat in an appellate hearing with, another one I've been in the courtroom. And I thought that judge, I'll say he or she, just for a tiny bit of anonymity, was a rude SOB in questioning the lawyers. So that one is wrong. They should set the example. Even when it's brought to attention, some get it, some don't. But there's really no mechanism to address because they don't really listen to their peers. But if there's a system that says, I don't know, I've been floating this on with some idea around in my head for a while. If any of you think it's a good idea, help me come up with a way to maybe do it. On to your next one. They're haranguing you, etc. Do you know how totally frightening it is for a judge to impede the adversarial process and zealous advocacy? Where's that line? When is it part of a reasonable litigation strategy versus you rude SOB? Now, if it's a really rude SOB, I think I have done that. But there's a line, and you hold back. Some judges won't say anything in a jury trial. They won't ask a single question of a witness because the line is so critical. Others will insert themselves quite substantially and destroy the trial. It's happened. But that is a tough one. I think the judge is always going to err on the side of letting you fight in the pit until he has to have the bailiff break it up to overstate it. No help, but that's the way I see it. Any other questions? Hey, you ate up 9 of our minutes. Good work.
I have a question.
Yes, oh, there you are.
I worked for a long time with Robert Wallace at a law firm.
I know Rob very well.
And he was always a very good litigator, very fair with people, worked hard. And he would represent the client to the best of his ability. When I was there, I observed that he wrote a letter once to the opposing counsel, whose wife was gravely ill, dying of cancer. And in that letter, he said, this practice of law that we do sometimes gets really ugly. And I want you to know, it's almost like he gave him amnesty. He said, I want you to know that I'm going to be patient with you on your pleadings and on your filings. And if you're late, don't worry about it until you get through this. And I thought, after I'd watched him practice law for all this time and he'd been training me, that was the greatest lesson I'd learned.
Mm-hmm. I think that's a beautiful lesson, and I think we should look for those opportunities, but then don't ever forget. I know Rob, he's a great lawyer. I've dealt with him from my first days in practice, and my position with that would be do that whenever you can and pray that you don't get in a position where your client's going to say you have not served my interest because you cared that this guy's wife was gravely ill. Now, I'll tell you, every judge I've ever known will back you up on that. Every one. But you've also got to have confidence in yourself that you can control your client. We hear client control. It does matter. It doesn't mean telling them what to do. It means telling them they hired you for a reason. And if they don't understand that reason and hear your counsel, it maybe is time to bail, not that you always can. You got a question?
You know, I actually added a couple sentences to our engagement letter that says that we have to abide by the rules of professionalism and civility in our practice, and that extends to using our discretion on deadlines and extending deadlines for other parties for things. And our clients signed that engagement letter, so I hope that protects me.
It's a tremendous protection. I taught pretrial practice for 3 semesters, and our first thing was the initial client interview and the engagement agreement, and I think it was done pretty generally. I just did a small section, but I always told them to put something like that in and attach the rules. Now, the rules of professionalism, the standards of professionalism and civility, I have run into terrible problems with that. I mean, Standard 14 would have counseled that the lawyer who said, you're late, too bad, so sad, should have said, you're right, I've got your arguments, I'm already working on responding to them. The certificate of service isn't really the issue, I know that. Go on, it's fine. It's not changing my position. But I have yet to figure out, frankly, as a judge or a lawyer, what teeth there are in those. They're aspirational. You don't find them addressed in the OPC, and candidly, 2 of my worst experiences where OPC lawyers didn't follow them. One withdrew a stipulation for a continuance when I didn't accept a settlement offer. I got it back within 10 minutes. And another one said, we don't stipulate. There's a standard about stipulation. Well, we don't because, and their reasoning was, we don't stipulate because it's not our position to tell the panel what's right or wrong. Well, but you could say that a phone call happened on X, well, in this case, the first paragraph of the NOIC facts refer to an incident that happened 10 days before my client's lawyer had any involvement at all. And it was a very prejudicial paragraph about damage to a child because of something that happened at a school. And it was a very sad story, which was totally unrelated to what else went on. They said, that's in there because the mother said it. So have I made you feel pretty happy about this role we all have? I'm hoping. I think we are about out of time. You've been very patient. I hope you haven't been too bored, but it's been a pleasure to be with you.